Hey everybody, it's Ron and Debbie. We're back for another lesson this week.
I'm Ron. You're listening to Debbie.
Okay, this is a Q&A in response to lesson 147, why I no longer assign contracts to buyers.
Okay.
So these are some questions, Ron, that you had directly come in from our Gold Club members.
Okay.
The first question is, are you saying to always do a sandwich lease option when doing a lease option?
I am saying that is if in fact you're leasing it from the seller and not buying it from the seller. Listen, you can buy it from the seller with either owner financing or they deed it to you subject to, in which case then you lease option it out. That's not a sandwich. A sandwich is when I'm leasing it and then subleasing it. And to answer your question, yes, I am suggesting that you always do a sandwich lease for all of those reasons that I stated in the previous lesson, of which I bet you Debbie's going to make me restate it. Am I correct, Debbie?
Probably.
All right.
I would bet on it. Okay, next question was, so one of the reasons to stay in the deal is to benefit from the increase in value of the home if the buyer should leave one day, and or the debt pay down of the loan in the future. Weren't those the reasons to give the new buyer with an over-leveraged house?
Well, now, if we're talking about an over-leveraged house, that would pass on to the buyer, but I would still do the sandwich lease it to the new buyer, and then assign it back to the seller for the other reasons that you haven't discussed yet. However, be very careful about doing that. I mean, come on, the value will go up, the debt will go down, and what do you gain by assigning it? Think it through at least first before you assign it back to the seller and get out of it. What do you gain by that? Nothing. But what do you gain by holding on to it? You may get some more profit. Don't forget that buyer might move out on you and forfeit that deposit as well. And in the higher priced houses, that's a lot of money. But on over leveraged houses, you're going to be more prone to deed it, or not deed it, but assign it back to the seller and get out of it. But if it's not over leveraged and you got some equity in it and you got some monthly spread in it, then I wouldn't assign it back to the seller regardless. I'd stay in it.
Okay, Ron, which takes us right into the next question that is relative to that. I have an issue with the first month's rent I ask for and get on an axe deal. When I assign the tenant buyer's deal back to the seller and release the seller from the original deal that included me getting the first month's rent, that would cancel the agreement for the first month's rent. How do I deal with that, and on which contract?
Well, I don't know why you think that cancels the agreement for the first month's rent. Your agreement should simply state, when you're dealing with a seller, that rent to them will begin 30 days after you install a tenant buyer. The fact that you've collected that from their tenant buyer does not change that deal. So I'm not really sure I understand that question. I'm under no obligation to give that first month's rent back to that seller just because I've assigned the contract back. And if it did come up, I just say that was a portion of my fee. That's how I get paid. That's how I get compensated for performing the services that I have.
Okay. Okay, next is from one of our members in Texas.
Okay.
I live in Texas, and sandwich leases are not allowed here.
Correct.
In the video, you say if I assign my lease option contract to a tenant buyer, he or she cannot use that assignment fee for down payment.
That is correct.
But a non-refundable option fee can be used as a down payment if I am in the middle in a sandwich lease.
That is correct, and you are correct. You can't do sandwich leases in Texas. However, if I were in Texas, I would buy with an all-inclusive trust deed and sell with an all-inclusive trust deed, frankly, and get lease options totally out of the picture. But also remember, if you buy with an AITD, you can still lease option to the tenant buyer. As long as you own the house, you can stay in the middle and lease option it out as well and collect a non-refundable deposit. It's just that when you don't own it, in Texas and Texas only, if you don't own it, then you can't sandwich lease it.
Okay.
Okay?
Okay, this draws a question on wholesaling properties and assigning the contract to investors. I'm new to this, and I'm curious as to whether this could be construed as acting as a realtor.
Well, that question has always come up, but no, I don't believe it can be, as long as you don't look like you're acting as a realtor, which is why I want you to stay in the middle on these sandwich lease options, because it looks too much like you are acting as a realtor. If it is real crystal clear that you never intended to lease the property or buy the property, but you're simply putting buyer and seller together. When you, however, put a property under contract from a bank, it says you're going to pay cash for it, and that closing has to take place. To assign that contract is a totally different thing. Number one, it's not owner-occupied. And when it's not owner-occupied, that takes it totally out of the issues with owner-occupied properties and all things that are concerning owner-occupied properties. When you're dealing with non-owner-occupied property, you're in commercial, and all of those rules don't exist. But when I have it under contract to pay cash for it, I got no problem signing that contract. Been doing it for years, people doing it for years all over the country. But when I'm dealing with a seller and an owner-occupant type buyer, I'm gonna be a lot more careful that I don't look like I'm acting as a realtor. And look, you gotta have it under contract before you can go find the buyer anyway. But if that's all you're doing, is putting it under contract and assigning it, seems to me like they got a good case if they ever wanted to pursue it, that you're doing nothing more than acting as a realtor. However, if I lease it and then I sublease it and I'm in the middle, there's no question I actually closed on it and I am not assigning it, I'm acting as a real estate investor. Now, that's of course my opinion. You're certainly free and probably advised to go get your own from your own attorney.
Okay. What if I don't have a LLC?
Well, you're going to need an LLC, but you don't have to have an LLC to make money, but you might as well get one to protect yourself. Remember, if you don't have an LLC, all the contracts are going to be in your name, and I really don't want to see that happen. If there's ever an issue, then you're going to be in it. If it's an LLC, then your LLC's in it. And if your LLC doesn't own any assets, then it protects you against all of that liability. So besides, you're going to need an operating entity. Some entity needs to be doing the operating, paying all the expenses of running your business, paying you for that matter, paying your VA, paying Pat Live, paying for your training. That should come out of your operating entity, and generally that's an LLC.
Okay, Ron, I think that's all the
That's
questions we had. That was it.
Okay, all right. See you guys soon.